Hi, everyone. A very good afternoon. Thank you so much for joining us this afternoon. My name is Neha Chaudhari. I'm a partner with Ikigai Law. I'm joined here by my partners, Aman and Sreenidhi, who will smile and wave for the camera. There we go. Thank you for making the time for this conversation that we're having on the Data Protection Act. We very much appreciate it. I know everyone's been flooded with a barrage of content on the new data protection law in India, as we're all trying to wrap our heads around um, what this new era means, something that many of us have been working on for a very long time, and very excited to finally see this alive and well and kicking. So thanks very much for joining us. The way that we thought that we do this is, of course, most of us are well acquainted with the Act and the rules and all of the various provisions by now. So the way that we thought we'd do this is to focus on key questions that are emerging as different folks are reading through the law. And all of us are trying to understand the meaning and interpretations and implications. So what we've done is we've solicited questions through the registration form that we'd circulated. Some are questions that have emerged from conversations that we've been having with stakeholders, including our clients. Some are questions that people have separately sent in to us. So we're hoping to do this in a question and answer format today. What we've also done is, we've also been flooded with a series of questions, I think like 300 plus at last count. So what we've done is we've categorized them into major themes that we've seen emerging around notice and consent managers, implementation timelines, next steps and what they look like for data fiduciaries and data processors, significant data fiduciaries, perhaps contractual obligations, verifiable parental consent and children's data, and very specific sector-specific questions that we've received as well on health, on finance, etc., etc. In today's conversation, we want to focus on these 4 or 5 themes that you see on the screen in front of you. What we'll do is we'll run through, as we'll be having a conversation, Aman, Sreenidhi, and I. You might hear some disagreement, you might hear some different perspectives. I don't want to say that we've got all of our positions internally completely figured out as well, because we do see different positions emerging, including across market practice, as different folks are working through the implications of the different provisions and how it applies to their respective business models. So this is very much going to be run as a conversation that the three of us are having on these 5 or 6 big themes. We very much intend to pick up all of the other themes that have come our way as well. So what we'll be doing is we'll be perhaps running another 2 or 3 sessions. We'll share details of that on our LinkedIn, and we'll reach out to everybody that's reached out and expressed an interest in the conversation as well. So it's just that it's not humanly possible for us to do all of this in one session today. So we are going to focus on these 4 or 5 slightly more big picture horizontal things that are cutting across, and perhaps where we saw the maximum volume of questions emerging as well. That's something else that we've taken into account as we've prioritized this as well. I'll pause with that. Srinivasan, maybe I'll hand over to you in case you want to come in. Maybe just give us a little bit of the big picture stuff, what your read of the law has been, and maybe we'll take it from there and dive right into the questions. And any other context that you wanted to set, if I missed something.
Sure. Thanks so much, Neha. Hi, everyone. Thank you for joining us. I think Neha's laid out all the context but just maybe a couple of themes. Do feel free to keep your questions coming in, even on the chat. Our colleagues, Vijay and Pallavi, we'll be responding to some of those questions on the chat as well, as much as we can take those. And I think in terms of the law, I think we're all familiar with the basics of the Act, basics of the rules. We're just going to focus on Q&A and questions today. But just so as just in terms of the rules, the final ones that have come out, not as many changes, actually just incremental changes from the draft that had come out in Jan. So it's largely similar to that. with a few incremental but meaningful changes. And maybe I can just start off with what are the key timelines under the Act and the rules. That's something we've been asked from a lot of quarters. So as all of you, as many of you would know, there is an 18-month runway that companies have for compliance. So all substantive obligations actually are operationalized at the 18-month mark. So we have a 1.5 year window to get our compliance programs in order. Immediately, what will kick in is the provisions related to the establishment of the Data Protection Board. There is a 4-member board that will be constituted. We don't know as yet who the members would be, but those are the provisions that will immediately be enforced. And for consent managers, there is it's after 1 year that the whole framework will be operationalized, where companies can apply to be consent managers. So that's more on the administrative side as to when the law is coming into is kicking in. Maybe I can, any thoughts, any questions, Neha, Aman, or I'll maybe start with the first one, which is what are the big changes from the earlier draft on the final one. So again, largely similar to the draft that had come out in Jan, but there are a few changes. The first is in the provision related to notice. Notice earlier said that a lot of it is similar, that it has to be presented independent of other and understandable independently of other information that the data fiduciary shows to the individual. It has to be in clear and plain terms. All of that is very similar. Earlier, where there was a reference to itemized description of data, that you put out an itemized description of the personal data, which still continues. But there was also this requirement that the list of goods and services also needs to be itemized. That has now changed to a specific description. And earlier, where there was a singular purpose that was listed, now it could also be specified purpose or purposes. So we think the impact of this really is that there is some recognition that there could be more than one purpose associated with one attribute or category of data. So with the removal of the word itemized, also what we think is there is some level of bunching together purposes, uses, goods or services, but alongside having a detailed list of the data attributes. So some level of bundling, but we're also not reading this to mean that it's you can put everything together in one kind of a catch-all notice framing, and I think we'll come to that in the notice provisions as well.
But
But
would
just
we
to
say that it's a slightly better, would we say it's more reasonable than what we saw in the draft rules?
yeah
As in, has it
yeah
gotten better? If I were a company, does it make my life easier to have it in this form, essentially?
yeah yeah I think the fact that there is a reference to purposes suggests that there could be more than one purpose which is linked to a particular data attribute, and you could view it in one bunch together. So I do think that it becomes slightly more enabling and permissive, because a very strict reading of the earlier draft would suggest that, which said itemized description of goods, would suggest that there is data, purpose, and yes or no. I don't think that that's happening right now. It is still data, but purpose or purposes, and there is some consent that you could take for those at the same time. For instance, there are many uses that could be enabled by the data. Like you could be using the data for, let's say, verifying identity of the individual, or for network security, fraud prevention. Those are all uses that are enabled by the processing. But that doesn't mean that one has to take separate consent for such purposes. And you'd be able to club those together.
Maybe we should, I know there were a couple of questions, Vidhi, if you just want to move on to the next slide. I know there were a bunch of questions that we had got around, whether a standalone privacy policy is okay, etc., etc. Do we just want to segue from this maybe into talking about what should be the form of the notice, really, right? Do we need, I thought this one actually was a very interesting question. I know you and I, Sreenidhi, have been going back and forth on this, and maybe Aman should be the tiebreaker. But do we need to do both? Do we need to do a standalone notice which is clear, simple, etc., etc., plus have a privacy policy? Or is there that is option one? Option two is standalone privacy policy, just having one privacy policy is okay, and we don't need to do anything else. Option 3 is maybe a standalone privacy policy is okay, but we should make changes to how we're describing data protection activities in it. Maybe we need to, you know how some platforms have now started to do a TLDR section on top, or give you like a simple version followed by a complicated version. Yeah, folks, if you just want to talk through a little bit about
Sure.
the form and how you're seeing this, right? And a related question again on UI UX, right? Because it's, yeah, it is a related question.
Yeah. Yeah. So maybe I'll just jump in there. I think option 2 that you mentioned, that you have a detailed privacy policy and maybe simply provide a link to that privacy policy, I don't think that works anymore. Privacy policy, I would read as a detailed statement of all data practices of the company across different products, business lines, whatever you're doing, your organizational practices. It's like a statement of your privacy practices that you've put out for the world to see. It could bunch together different kinds of activities that you're doing. It would all the purposes that you're collecting the data for. But because the rules specifically say the notice has to be given in a way which is understandable independently of other information, it's presented separately. I think on the UI or whatever mode of data collection you're using, there is some notice standalone which is specific to that context that would have to be displayed to the users. That would not mean that a privacy policy can never work as that standalone notice. Perhaps there are instances where there is a discrete, data collection activity that's primarily what the platform or the company platform rather is doing, and maybe that listing of data and the purposes, that is what the primary piece is in the privacy policy. But you'd still need to curate it and present it with some care. But I think that old system of just having a privacy policy which lists everything and merely linking, that I don't think works anymore.
So wholesale UI UX changes?
Yes, reviewing the UI UX definitely to see at what stage, what is the data that's being collected. I think many times in the past also we've discussed those just-in-time notices, pop-ups, just a more privacy-conscious UI. But just this notice still needs to have enough information. And typically, at account creation, sign up is when you'll be displayed something to indicate that. Yeah, Aman, you want to come in?
I think I agree with you. I don't know what tie I'm breaking, Neha. I don't know which way you were leaning on this, but I tend to agree with what Sreenidhi is saying. I think they're meant to do the privacy policy and the notice are two completely kind of different pieces which can speak to each other. And I'd love for you to just maybe explain, or I think it'll benefit the room also to talk through a little bit about what kinds of just-in-time notifications we could be seeing, which will meet this requirement, right? Like, why are we asking for this information at this stage? Just even a hovering text saying we need this to be able to contact you for, if you're an e-commerce site, we need this to be able to contact you if we're ever doing a delivery or whatever that is, right? Just very crisp language there, I think, is what the expectation that's coming out of the rules now is.
Yeah. Yeah, fair. Yeah, I think in address, you gave that example of delivery as to why something is needed. Location as well, rather than me manually entering some, I don't know, address or location, automatically identifying that contact book so that we can access. Let's say I'm delivering groceries to somebody else, and it automatically it asks for contact book access, but for the limited purpose of that delivery. So at that point, if there is a prompt or there is just a statement to me to clarify that, and then eventually it's used only for those purposes. I think those, while I understand that may be some text on the UI, but I think very sharp statements also could work. A lot of times it is self-explanatory as well, but maybe, a few words here and there would just make it a little clearer to the user that this is the purpose for which it's being asked for and collected. Also helps actually generate some trust as to why we're doing this.
So I just want to jump in here, and there's a bunch of us sitting here as well, off screen. I know Astha is sitting here, one of our senior colleagues as well, and do a lot of product work as well. This languages business has always troubled me. I know it's troubled many of us from the beginning, right? is it now? There were a few questions that had come in around what is the obligation? Is it all Schedule 8 languages from the very beginning? Number one. Number two, is it that if I as a platform have some way of ascertaining where my market is or where most of my users are, right? If I'm tracking geolocation data, etc., can I restrict it to those? Let's say that I am an app that is operational only in 5 states in the south of India. Is it possible for me to do that? And where does that, I mean, see, with privacy policies, etc., which is a static document, it's one thing. But what happens to just-in-time notices? What happens to like consent pop-ups that are coming in? Is it okay if I have it in English? Should I have like a little thing at the bottom says, that says read it in Hindi, read it in Marathi, read it in something else? So like, yeah, any imagination? Have we come across organizations doing any thinking around this? And yeah.
Yeah. So I'm not reading that provision to mean that you have to provide your apps in all of those languages and all the content of the apps. I think that would be excessive
Too far.
because this is focused on data and what is, how you communicate to the users, what is the data that is required. But the legal notices, the at least the original at the time of sign up, there is a big pop-up, there is some listing of these are the purposes, these are the uses. Even there, I don't think the expectation is that you put everything out in all languages, because that also means like scrolling through so much content. But the user should be given the option to be able to access the notice in these languages. So maybe what we'll end up seeing is either links or drop-down menus where you're able to click on a particular language and then access that notice in that particular language. At least in the languages that the app is available in, that those links are clearly provided. But yeah, I don't think there is, if the user does ask for it or wants to, we need to provide the user the option to be able to access a notice in that language. But I would not read that to say that every statement on the app needs to be translated to all of these languages. I think that would be extremely operationally challenging and actually infeasible.
I mean, and should it then be limited to if you're like Neha's question, if you're operating in certain states, and I mean, should it actually just hinge back to if you provide services in multiple languages, then obviously your notices should also be there. But if you're providing a service, I mean, the larger interface is only in say in English or in Hindi or just a couple of languages, then would your notices also only need to be in those? And in response to a user saying, hey, can you send me, this is not my first language, I want to understand what I'm signing up for. At that time, you do this as a response.
In response to that. Yeah, that may be a pragmatic way of approaching it, that if the app is or website is available in these certain languages, then the legal notices and the documentation is also drafted there. Alongside this, if the user asks, then you provide. We have also seen companies say that in any case, if we have to keep it ready, if a user is asking us, then well, we might as well just get them translated and do it. We do expect to see translation as a service also emerge, where a lot of privacy notices are eventually then translated into different languages. It comes with its set of challenges, because one change would mean change across all of these, ensuring that those are also accurate, because the user is still going to rely on the notice in the language that they've been shown.
Got it. I want to so I think two related questions. We touched upon this a little bit before when we were talking about Rule 3 and this I think the language in 3B especially, which is again some questions have come up around that. I think safe to say take it or leave it approach, etc., can no longer work. You need to do granularity, specificity, etc. Will this mean making changes in terms of use? Potentially, it may link back to the privacy policy, etc. But I suppose in practical terms, privacy policy is really the living document that we're looking at here in many ways, shapes and forms. But I thought this one was a interesting one, right? Like while we are moving away to granularity, what is the level of granularity that we're looking at? is it okay for me to say, for instance, the example or the question that we're seeing on the screen, is it enough for me to say service optimization? Does it satisfy the requirement under Rule 3B, where we say the specified purpose or purposes of and specific description, so on and so forth? So would a generic category suffice? I don't think, I mean, I'm inclined to say yes, because I think it's unreasonable to expect, you know, beyond this a level of detail. And also the point that we were making earlier in terms of, they've specifically said that it's no longer an itemized list anymore, like the move from itemized to specified purposes. But tell me if you disagree, either of you.
Yeah. I think that's fair. But I would still perhaps steer clear of very broad or maybe generic statements, like something like just analytics.
Okay.
That may not give user enough of an impression. Service optimization has a specific connotation. So perhaps that something like that works, but a little more context might be helpful there. Just to, I think the idea is that we've made the effort to inform the user what is it that we're going to do with this. Analytics may not do that. Optimizing our service, improving our products and services to deliver you, I don't know, better services, personalization. That level of detailing, I think, is desirable. On where we're not doing excessive, because I mean, even optimization helps us understand where we are headed, but not but enough to at least, you know, provide individuals some idea of what's happening with their data. Of course, the data we must still list because it is an itemized description of the data. So categories, and within that, what is the data we do list out. Purposes, uses, services, and goods, we still do list out what are the users enabled by it. But perhaps not breaking it down even more than that, and also leaving some room open for it may not be something we're doing you know, at the moment. It's on the pipeline, so there are multiple different kinds of products or services of the same nature or the same category. Maybe those could be listed in one category bunch together.
Got it. Aman, do you want to comment on maybe like the consent withdrawal type pieces? This is another one of those. I feel like Aman is going to just be tiebreaker on this call. This is another one of those where when Srinivasan and I were having a conversation before, the requirement is the phrase that the law uses is comparable, right? Like the ease with which you give consent and the ease with which you're withdrawing consent, this needs to be comparable. Now, I'm paraphrasing, of course, but we were wondering what that really looks like in practice, right? There are two ways. So, for instance, if I click on a button that says, you know, whatever, I want to withdraw my consent, and then it opens a pop-up of an email client where I'm supposed to send an email, you know, to this platform or service, etc., etc. That's scenario one. Scenario two is maybe you just have toggles where you say given consent, withdrawn consent, etc. Should it be that easy? Is that the standard of comparable? Scenario three is, what if there's a cooling off period, right? I say that I want to withdraw consent, and the platform says, are you sure, etc., etc. I go through like the series of questions saying yes, 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 I am very sure, I am positive, I've thought about this long and hard. And then they say, okay, you know what, we'll check back in 15 days, and then if you're still sure about it, you know, we will process this withdrawal request, etc. Right? So out of these, I mean, I thought that the email model made me slightly uncomfortable, but Asta is also nodding along. I thought that made me a little bit uncomfortable. We thought maybe the toggle might be, it doesn't need to be the same, which is the point that Srinivasan was making. It has to be comparable, but it shouldn't be the same. So maybe we don't have to go so far as the toggle, but maybe the cooling off period kind of thing might be okay. But wondering if you have a view, or Srinivasan, if you want to come in. Or, yeah.
No, I agree with you. The email bit doesn't, I don't think that works, right? And in fact, that's often the example given as to why they've had to now specify this as clearly in the law, because you make it so easy to get onboarded, but it's Hotel California, right? You can never move. So, and I mean, then the toggle might, honestly, I think as easy as it is to onboard, I mean, that's not a really easy standard to define. but it should be a few clicks is how I'm thinking about it. Like you could have a section in your settings which is where you talk about privacy. So it's your section for control, and there you have a button which says I wish to withdraw or something like that. That kind of toggle. On the cooling off period, again, I think that I see a very strong business reason to do it, and also from a user perspective, right? Like
Yeah.
I might just be fooling around with these new settings because I'm also because as a response to these rules, businesses are going to update their UX, and I might literally be playing around, and I don't want to end up in a situation where I have lost, my settings, my personalization. I don't want to have to input maybe all those addresses, all of that again. But with a smart way to do that could be, sure, we acknowledge that you want to withdraw. We are going to stop servicing you immediately, but this deletion of anything that has to happen will happen in accordance with some retention timeline, right? Like, very often you'll need to retain some records just for legal purposes. If you're just to guard yourself against a consumer case, for instance, you need to have that for X amount of time. So, and if in that time period you change your mind, we have the ability to bring it back. But for now, we're turning off us touching your data in any meaningful way. But we're not necessarily going to immediately delete it and delink it. I think is a good middle ground, which serves, from that perspective of minimizing friction when you're in and out, but also giving users that level of control and surety that I can play around on these services and not end up accidentally
deleting my account. Yeah.
I mean, I'd be heartbroken if my Wordle streak suddenly disappeared, right? So I don't want to risk that.
Such a nerd, Aman. But tell me if you have a view on this business of anonymized data. The example that we see here is of AI model, but it's a question that we've seen all come up in multiple different contexts as well. Just a one line, and I mean, because you brought up legacy data and data retention, I want to sort of dive into some of those questions as well. But quick thoughts, either of you.
Anonymized data, does the use of anonymized data for AI model training require consent? As such, anonymized data, once anonymized outside the scope of the law,
but to anonymize, we
is
should
not
take
required.
consent.
Processing itself, if the question is whether something like this should also be mentioned in your privacy notice, that this is something that we do. I think increasingly we are seeing at least larger platforms mention this specifically. In some cases, also allow users the choice to be able to say no to this. I think would depend on the platform, the use case, how critical this AI model training is for your entirety of your operations. But I do think it makes sense to at least have the disclosures in place. In your privacy notices, the fact that we use data in even anonymized format for AI model training. But once anonymized, as such, no consent required for processing it further.
Consent manager, there are a few that have come in the chat as well. Yeah, I mean, like there is this, I think the big picture question really is, do we all need to use consent managers, or is there a workaround?
No, consent managers are not compulsory, not mandatory. A platform can very well, companies can build out their own consent management, architecture system, as long as it meets the requirements in the law. It's not mandatory. Yeah, but I think there are some tricky pieces there which come in, let's say, because consent managers, as envisaged under the law, are something that an individual can use to be able to manage her consent more effectively. So if a user has a certain consent manager and wants to be able to provide her consent only through the consent manager, would that mean that the data fiduciary is then obliged to also onboard and integrate with that consent manager? Because how else would that consent get engineered? This is a tricky one, which I don't actually know how it's going to evolve here, because the only way that I can envisage a consent manager working is if they are also onboarded with the fiduciary, which would mean systems that speak to one another, are interoperable, some engineering effort on both ends. The platforms, consent management platforms, also get built in a way that they can attach to different kinds of systems. And this would be, for an individual, this would be so many different services that I'm using, from a telemedicine platform to a OTT to search, like anything really. And if I want to do all of that through one platform, then it has to, that platform has to speak to that side and to me in a meaningful way. And I don't think we have enough clarity, at least in the rules. Perhaps this is something that evolves in the market through subsequent guidance. As such, letter of the law, not mandatory. You can very well build out your own consent management platform. We are actually getting a lot of queries on is it mandatory? Is it just a plug and play tool that we can work with? I mean, eventually, if there's a DS obligation to show that their consent meets the standards in the law. And I think, there a couple of months back, there was this business requirements document that NEGT MeitY had put out in response to a code for consent, like a hackathon, where there were some requirements on how you build out that consent architecture. I wouldn't read all of that as a legally binding document, but at least that's some direction of what a platform, what an architecture might look like. There are some parameters that you'd want to look at, but it does give the sense that one can build that out one yourself as well. Yeah, and I think there were a couple of questions in that vein on whether we continue to collect consent independently. You can, and I think even for consent managers to develop, while there is a 1-year window for a company to apply to become a consent manager, which means that the board would have been set up by then and will be accepting these applications for registration. But I think there's some way to go. Until consent managers like they're envisaged in the law are actually operationalized. We don't also as yet know what is their monetization revenue opportunity, especially because they are structured to be sort of data blind. So all of those things as well, where and let's see to what extent these consent managers emerge. We do see a lot of consent management platforms which are just like any other service provider that is building out that infra for you, the consent platform, but that's a little different. That's not something that's like a service provider to the data fiduciary. Like any other processor. Those I'm sure, I think we're seeing some of those in the market as well that'll emerge, but that doesn't necessarily mean those are the same consent managers that are envisaged under the law.
But do I have to, as a company, give either or option? I think this is one of the questions that have come up on chat as well, and maybe more than one. While there is no mandate to do it, what if I want to do it as a company, right? And I want to route everything to a consent manager, but you as an individual and you as a customer may not want to work with that sort of consent manager. Is such a scenario possible? Or is it basically up to the businesses to decide how it is that they want to basically do consent management? Yeah.
So the consent managers under the law are actually almost like a service provider to the individual. It's like the individual is able to, through this consent manager, review, withdraw, manage their consent. Whereas typically what we see platforms grappling with today is, have we built this out? Is this consent means or method of taking consent and giving notice, all of that okay? So I find it a little hard to envisage a scenario where it's actually the platform which is saying, no, I must use this consent manager, and for the it's kind of option, like, because I'm just envisioning it as here's a dashboard for the user. It wouldn't really matter whether it's that company itself or it's a backend service provider that is displaying that consent modal to the company, to the user. But the other way around is trickier. I think that's what I was trying to get at earlier. If the individual says, no, I will only give my consent through a consent manager, that would mean some engineering effort as well, I believe, for the platform then to say, no, we'll integrate with this consent manager.
But I mean, can you reasonably read a law to kind of create that mandate, right? Where you're effectively telling me how I need to go about executing one. Is one to have an obligation to take consent, which is, explicit, etc., etc., etc. But can you go to that level of granularity, saying if a user only wants to use a consent manager, then you have to oblige? That seems a little bit almost like a consequence of a reading of the law, which is bordering on slightly absurd, if you ask me honestly. I mean, I would go so far as saying at some point the law can't get into to that granular level, telling me how I need to do my business, right? Can't really be the expectation. I mean, I'd be willing to stick my neck out on that one. I don't know if Neha, do you agree?
I think so. No? I don't think that the intention of the law is. I don't think that. I don't think the intent for it to be absurd. And like Sreenidhi said, I feel like a lot of this will evolve, and maybe 1 year later we'll be having a completely different conversation. But at the moment, I don't think I disagree.
Yeah, I'm not reading this to mean you must have a consent manager if the user so directs. I think just to take up maybe a couple of other questions on who is it that can apply? Is it only existing companies? I think there are a couple of requirements that are set out in terms of net worth and financial condition, but nothing else really. Anyone could apply to be a consent manager, subject to those net worth and other criteria. There are some operational details, like you have to not yourself read the contents of that information. You have to data blindness, and you have an interoperable platform through which individuals can review, withdraw consent. So you build those out in that fashion, and also what the liability framework might be. So no specific penalty in the law prescribed for failure to, but there is the residuary penalty, and if the consent manager doesn't adhere to all of the requirements, operational details that are set out in Schedule B part, the first schedule actually of the rules, then that would mean that they've breached their terms of the registration and are not likely to be allowed to continue. But more specific than that, I don't believe that there is a penalty that is prescribed, but there is the residuary penalty for them. And I think if this is an interesting one of whether the breach on their platform, are they treated as a fiduciary or a processor or an intermediary? I think if there is a security breach, and there is a breach of the terms of the registration, while I mean, I'm inclined to think of that as a fiduciary breach. Well, there are no other penalties in the law in any case directly for the processors either. But again, I'm reading consent managers to be entities that are accountable to the individuals directly. They are in some kind of a fiduciary capacity, even if they're not data fiduciaries that are processing data for providing a service. And I think just on the question of can third-party tech vendors act as consent managers, I think we did touch upon this. The regulated consent managers that are kind of set out in the law, that is something which is it will eventually be these third-party vendors, but they're both service providers to individuals and then in some way integrated with the fiduciaries as well.
Okay, I don't see anything else on chat either. Maybe we should move on. I know we've touched upon fiduciaries and processors a fair bit, and I know that that's a that's a bit of a tricky one. Always it tends to be the most contentious one for many of our clients as well. But I mean, thoughts on when and in what case you become a joint fiduciary, you become a joint, you are a data fiduciary, a joint fiduciary, or a data processor. I mean, like the first example, and then maybe we talk a little bit about significant data fiduciaries, etc. But yeah.
Yeah. Sure. I think so. I think the principles in the law, and I don't want to go into it because we've discussed it so many times, and I'm sure everyone's heard it so many times. It's calling the shots, purpose and means. Whoever is controlling the data processing is the fiduciary. Whoever you're engaging for processing data on your behalf are processors. Joint fiduciary, I believe, will end up being very limited scenarios where both of them are, let's say, jointly creating some product, or it's some joint research, and so on. As far as the question where if it's a platform as a service, anything as a service provider, not calling the shots, if it's just at a as performing or processing data on behalf of their client, then they are a data processor, and the client is the one that's the data fiduciary. In I think that would be the principle there. Yeah.
No, sorry, Aman, you were saying something also. Yeah, no, then I just want to talk about the contractual stuff a little bit. And I know we've spoken about this a fair bit as well. So if you literally just want to take 30 seconds to 1 minute on some of these 4 or 5 clauses that keep coming up and are the contentious ones, because I mean, the obligations really will flow through the contract from the fiduciary to the processor. If so, yeah, your usual something that we see constantly, those 4 or 5 big clauses, and then we can perhaps move on.
Yeah. So the law doesn't specify what all should be included in the contract, but typically what we see is defining the relationship. I'm the fiduciary or the processor. These are the purposes for which you can process the data. Just is limiting those purposes, defining what really is it that the service provider will provide. Data processor will process the data for what purposes. Typically, there are restrictions and requirements around security safeguards, that this is the minimum level of security that we would expect. It could be that there is a reference in the clauses, and you may also want to list out if there are any specific security compliances, SOC 2 audit, whatever it might be, ISO 27001 and others. If it's in some specific regulated industry, then those security standards as well that you want to pass down to your processor. There would be breach reporting requirements that in case of any security incidents or data breaches, notify us promptly, so that then we are able to report to the Data Protection Board and other authorities, and that you'll provide us reasonable support in responding to all of these in responding to supervisory authorities in breaches and other instances. There are typically some audit clauses as well that we see, which do get negotiated depending on what is the nature of the service. There are restrictions on appointment of sub-processors. Either sub-processors are only appointed with consent, or it is an approved, or it is an if we don't, there is an approved list of sub-processors, and if you want to go outside of that list, then you get, let's say, a 10-day window to object. There are, I think, security sub-processors. Yeah, many of them we've covered. I think the most important one is indemnities. Just really making sure that you are getting indemnified for any loss, any injury, any expense that you may suffer on account of the processor. And if you're on the other side, I know I've been speaking as though I'm the fiduciary, but a lot of us in the room will be processors and service providers. But typically, indemnity clauses are also fairly heavily negotiated, because the service contract may itself be, I don't know, 10 lakhs, but the penalty that you're being exposed to is like 250 if you accept uncapped liability. So just deciding and agreeing to some sort of either a cap or some caveats as to where uncapped liability, or what you accept uncapped liability for. So yeah, I think those are some clauses. I'm wondering if I think those that largely covers the different things.
Two follow-ups that I wanted to, which have also just come in live on the chat, right? One is just, do we have practical hygiene tips, given that it's ultimately the fiduciary that's responsible? I mean, some of the stuff that we've spoken about is contractual, but really just at like an organizational level, or when you're choosing who your processor should be, or you're selecting, or as a processor, you're looking at a sub-processor, what is like some, I don't want to say common sense, but also common sense hygiene, and any other sort of best practices that we should look at when we're choosing? That is one. And second is just flipping that, right? So then therefore, as a processor, what should I expect? Should I expect like a lot of due diligence questionnaires and things like that? So yeah, just
Yeah.
pick that up and move on. Yeah.
Sure. Yeah. It just can't just be a contract and you're done. Because the full onus of compliance is on you, and if you do engage somebody without doing any level of diligence, then well, your neck is on the line in all cases, and your penalty is unlikely to be reduced. If you've taken some mitigating measures, and that's a big factor that the Data Protection Board will hopefully take into account when adjudicating and awarding penalties. It's what you did pre and post any kind of breach or non-compliance. So some practical measures. So we've often now started seeing these questionnaires, which have questions around: do you have an information security policy? Do you have a data policy? What is really has the organization or service provider suffered any breach in the past many years? What do they do in response to that breach? What are their security practices? Also a little bit of what are the kinds of, if it's a particular industry, then have they serviced others in that same industry? What is their protocol around appointing sub-processors? What are the kinds of contracts that they downstream, clauses that they include downstream in their contracts with sub-processors? So those sort of questions. But I think the breach question is a key one. Really, have you suffered a data breach in the past? Have you left all your, I often used to use this example, and Neha would love, like, banana peels on the floor, window unlocked, and if you've done absolutely nothing, even as a service provider, at least some level of ring fencing, some questions you ask so that one can understand and gauge what the security and privacy ethos is of that vendor. And maybe we'll see a lot of this getting slightly more automated, with questionnaires that you often also see third-party vendors, and just that process is automated, or the company itself makes it a little more automated, where it's questionnaires and one fills yes or no questions and provides information, submits these reports, ask for SOC 2 or whatever, ISO 27001 certification details, and so on. So some hygiene practices there. And typically also, again, I think it would depend on the nature of that service provider. How frequently would you want to retain an audit right? What would be the extent of that audit that you conduct? Is it opening up all systems? Is it just we ask you for information and certifications and reports and licenses and you provide us those? Or is it a more extensive audit where we actually come to your offices and sit with your people and see what your databases and dashboards are looking like? So both pre-appointment risk assessment, contract, followed up with audits periodically.
Got it. And just one more thing, again, another question that had come in on retention, right? And this is, I feel, like a larger question on downstream obligations as they are flowing from a fiduciary to a processor. One of the questions was, whether you can go back to whatever the previous slide was. One of the question was, right now, the contract will say that basically a data processor will retain data for as long as necessary for the purposes of processing, and then after that you will delete it. Now, are we going to likely see obligations that ask data processors to retain it for that 1 year because is that an obligation that we see flowing down? Is there a risk that comes to a processor? Just loud thoughts, either of you, on what we're imagining here, and then maybe we can talk about SDFs a little bit.
Yeah. Aman, any thoughts on that? Yeah, I do see it maybe flowing downstream as well to maintain records for 1 year for abundant caution. You must also have those records because eventually it's you who's going to be in the firing line, really, with the regulator. But I do anticipate then that for some period that pass that on. I guess it also depends on the nature of the service provider.
How would that practically play out, right? Like, I mean, if I continue to engage you and I'm using your services, then my expectation of how long am I using you as a storage service? I'm also curious as to what you're imagining that processor to be doing for you. I guess that also becomes relevant, right?
Yeah. If it is an ongoing service and for some time, I think I'm thinking of actually storage as the primary service. But let's say analytics. I outsource some data analytics to a third party. There, perhaps it may not make sense to ask and tell them to retain that data for longer after the service. Yeah, after the service is complete. But you must have that data. You must have the outcomes of that data, because that basically, if a law enforcement agency or somebody comes knocking, you should have data about that user. I think that's where that's headed, that you have information if this is the order history, or if this is kind of the social graph of the individual. At least for a year you've held on to that. Let's say after account deletion, or any other such moment in time.
I feel like one of the questions in chat also, which is on, for a SaaS startup, a B2B offering an online HR platform, is consent required from each individual end user, or is consent from the client company sufficient? Do you want to take how you? I mean, the way I'm looking at it, the client SM, I'm not sure who you are, but we'll respond to your question live maybe, because it came up at this moment. The obligation of getting consent is actually on the client company, but as a service provider, the expectation will be that you will create the tooling necessary for them to be able to take consent, right? So you're not taking consent maybe as long as your role is limited to being a data processor on behalf of the fiduciary. If you're going to do anything else with it, to improve your own services, etc. In those circumstances where you step into the shoes and start acting as your own fiduciary, you will need individual consent at your level. But in most of the situations, I think it will be part of the service bundle that you offer your customers, which is the other business, on how a mechanism for them to collect consent from their users. Although an HR platform, again, I don't know if consent would necessarily be the right ground for processing in an employment situation. That also is a question that often comes up. Can you take consent from employees? But in any other example of a SaaS provider, I think that's how it will likely play out.
Yeah, I think aligned there. Just seeing any other questions in the chat
Maybe just quickly on significant data fiduciaries, because I do want to sort of talk a little bit about legacy and employee, the two other themes that we wanted to cover first. But do you want to take there were two interesting questions, right? One, of course, is the overarching stuff on what a significant data fiduciary does make. But if you go to the previous slide, Vidhi, just for a minute, there's this really interesting one on whether that determination happens at a product level, or does it happen, at the company level? Is it that if I'm, a large conglomerate and then I've got, is each of them going to be designated a significant data fiduciary? Do we see anything in the law that guides us on this, on how some of this determination might be made? Or do we have to wait to see what the board does?
Notification says. So the law pegs it to the entity, that SDFs are classified or will be classified or notified on the basis of certain factors like user threshold, volume, sensitivity of the data. Doesn't say user threshold, but yeah, volume, sensitivity of the data, risk to integrity, all of those factors. So it seems to be an entity level classification, but that may throw up a lot of operational concerns, especially if you're a business which has, whether you're a large business or a small business, but you may have multiple product lines. One could be B2C, but the other is SaaS or B2B. It would not make sense to apply, if for one product line you become, let's say, health data, anyone processing health data theoretically tomorrow gets notified, but that should not automatically mean for all the product lines of that business you become a significant data fiduciary, because there are DPIs that you have to conduct, data audits that you have to conduct. You have to submit those reports to the Data Protection Board, appoint a DPO, all of those things. So that is a tricky piece, which we've seen a lot of, and we haven't seen anything suggesting one way or the other in the rules. I wonder if in the notification there will be any clarification, and what that might look like, and also how it would be even drafted? Because if it's a company, how would you even differentiate among different platforms or different business lines? Operationally, it may not, like, it may be the same people also who are running those, but the businesses may be entirely different. And we actually haven't seen a lot of conversation either on this, but we know companies are grappling with this, on what potentially this would mean once the SDF classification comes out. Aman, I'm wondering if you want to add something there.
No, I think that's fair. And we were also talking earlier, like if you have multiple lines of business, one of the obligations, of course, is doing DPIs, etc. But you also need to have data protection officers. So would organizations prefer having one DPO at an entity level, or if you're arguing for this segregation along lines of business, then you need to have a DPO for each one? Like, I think there will be pros and cons to kind of each approach that you end up advocating for. And I think this will become an important. I mean, the SDF piece is while the rules have come out and we have a lot more clarity than we did, a week ago. This one remains a little tricky. I saw questions here asking when are we expecting the SDF notifications and all of that. I think one lesson we've learned through the last many years is we don't put numbers to these predictions. So that is going to be a very important piece, though, and I think we should continue to maybe harass people like me to give us some more insight into this.
Into what their thinking is.
Yeah.
Okay, awesome. Can we move on, Vinny? I know there were a bunch of other questions that had come in on SDFs as well. Okay, sector specific ones. I don't think we can make a blanket determination one way or the other that says all health tech companies, all fintech companies, etc., etc. But given volume and sensitivity, I would imagine that this is something that that obviously will cut across sectors. And our current data protection framework, I shouldn't say current anymore, our old data protection framework through the SPDI rules does imagine financial information as sensitive personal data. So I would imagine some financial tech companies definitely being classified as SDFs, but happy to hear if there are any alternative suggestions. And I think the larger question on, I mean, I know we're waiting for government guidance, but Aman, if you have a wish list from MeitY, what does that wish list look like? What should they do, and what should they keep in mind?
Man, that's a tough one. I've heard from some people, some quarters say, let's collect what we are doing, this exercise that we are doing today of collating questions and then getting answers to those. So some version of an FAQ which gives a little bit more insight into and helps us on that interpretation pathway. That would be my one wish, because I think everything else that needed to be said, people have had a chance to say before this, but now how are you reading it? If you've not changed the rules after hearing a lot of feedback on XYZ, do you think this interpretation works? I mean, some of that clarity on what, at least how they are reading it would be a useful outcome, if you ask me.
Okay, let me switch gears a little bit, Srinivasan. There's a whole bucket of questions on what do I do, right? I'm waiting and watching. I don't know what the determination is finally going to be on SDF, or at what point, or will I become, will I not? There are many organizations in this sort of in-between space, and we've got a bunch of those questions, not just through the webinar, but folks that we've been, generally having conversations with as well. And you will see that reflected here as well. What should I do from the perspective of sort of bracing for impact? Is there something that I need to do operationally, financially, from a governance point of view? What are some of these risk factors that I should identify in my organization right now, and such that the potential classification or designation as an SDF is triggered? And then what does it mean for me, sort of future and forward looking?
Yeah, sure. So I think the three major obligations for SDFs are: you do a data audit, you do a DPI, and you appoint a DPO. All of these in some way you are incrementally anyway doing as part of your full, DPDP compliance process. Like for a data audit or a DPI, the first step would be your inventorization, and at least identifying your entire sort of gamut of data that you're collecting. If you are large enough, you have a large enough user threshold, I would assume that I will be SDF and kind of prepare for that. Just even how would you present the findings of something like an audit or a DPI? So those, I think, foundational steps should anyway be laid out for all data fiduciaries, but more so for those that have a large volume of data, or you're processing some sensitive data, that in between bucket, which is not entirely sure if it will become SDF or not. But I think those foundational steps, and also all while you may not call them a DPO, but there needs to be some person, grievance officer in any case, who's responding to queries and all of that. But a senior enough person within the org, if you are at that cusp where you're not sure, means you're large enough, I think, or significant enough to at least have someone really think about privacy within the organization as the conscience keeper. Just today, I think we were having these conversations on who does the DPO even report to. Like, I think that people piece must also be thought of with a lot of care, whether it will be someone senior enough who's reporting to the I don't know, feeding into the CTO, CFO, where really your lines will be as well. I think that people piece also I would think of a lot more as any large organization that is on the cusp of being an SDF.
Okay. Aman, anything that you want to add on that? I'm also a little bit mindful of time. I know we want to do employee and retention, but I'm actually wondering whether we do that in the next one. And because I want to spend at least 5 minutes talking about some of the implementation and big picture and strategies. I think there's one question that's come on the chat as well in terms of going about mapping and inventorization, etc. So maybe we'll just take 5 minutes now and close with that. But let me know if either of you disagree, and we can pick this up in the next conversation. But Vidhi, if I could request that you move to the questions on the big picture stuff as well, please. We'll come back to these in the next conversation. And okay, we don't have a slide for that, but oh yeah, there we go. But yeah, folks, just big picture stuff. Maybe just we start by loud thoughts. Aman, either of you, how would you go about this? What does a roadmap for the future look like? um, recommended approach for organizations to do this efficiently. There was one really interesting one that had come in on what this means for general counsels. Yeah, so feel free to pick up any of these themes, honestly.
Yeah. I think everyone would have heard by now what the first step is, which is the data mapping, inventorization, really identifying and knowing your data assets. But I think maybe also just as a strategic piece, it may not be possible for one to run a compliance program across all business functions from the get-go. So maybe also that prioritization. So if we have a heavy customer focus, and we have employees, and we have vendors, and we have multiple different data principles, I think starting with those endpoints and touch points which are likely to be the most concerning. So your CRM, like marketing activities or campaigns, while you keep getting your house in order as far as your employees are concerned. But I think I would start with those priority areas. Even if I'm not able to just do 80%, 100% from the get-go, but identifying those priority areas and perhaps starting with those. And again, I think I already talked about this a little bit, but investing in those people and sort of processes, sensitization, awareness, but also someone to really drive this within the organization, identifying who that would be. Would it be the GC? Would it be someone in the tech team? Would it be CISO donning this hat? Is it a specialized role? Because one has to coordinate with all multiple functions, but identifying who that conscience keeper for data will be within the organization. And 18 months is not that long, really. I think time will quickly fly. So really, I think just if that part is not already done, then really doubling down and kind of identifying those themes.
Just building on what you said, Sreenidhi, I think getting the people in place, etc. I think fundamentally what that requires is buy-in. Firstly, right at the top, I think at a CXO level, you need that buy-in that this is something important for us as an organization to do, and then and yet at the same time, because along that compliance journey, you need support from all these teams, right? Where they need to know why you're asking them these questions about what, I mean, you need to build that, a little bit of that culture building requires that 18-month period will I don't know if it will even be enough for that culture building, but at least getting started on that, and that starts very often from just awareness, sensitization. I think, yes, I agreed with SS that, you start with some of the high priority stuff when it comes to the compliance part, but also organizational culture. How do you start building that? What are the measures you need to take? Becomes an important first step as well.
And would we imagine a lot of this being driven through the legal teams? I feel like that's a fundamental shift, right? Any new law, any new compliance with any new law, a bunch of questions, because it's something so horizontal that every product, every service, every business process that you have that's internal, external, every contract in some way, shape, or form is up for examination given the new data law. No matter what kind of organization we are, we all have personal data. At the very least, it's employees, right? So it's depending on, of course, on how the organization is structured. I feel like that's the baseline, but beyond that, I mean, it could be that the privacy function is housed within the legal function, especially for smaller organizations may not have a privacy function necessarily, or it could be that legal is anyway having overarching oversight of everything that goes on. But I imagine I do think that it will look different, at least for the foreseeable future.
Yeah.
Any closing comments or last words? Vidhi, I don't know if we had another slide on implementation, if there were more questions that had come in. But if not, Sreenidhi, Aman, any closing thoughts, any closing conversations? I do think that there are more questions on, just practical tips on friction-free user journeys, some big picture questions on, or maybe we'll close with that, some big picture questions on how do we do when there is overlap across different jurisdictions, GDPR, the Indian Data Protection Law, etc. And yeah, maybe that's the last one we pick up.
Yeah, I think for companies that may have already gone through this journey in other regions, at least there's a good starting point. It would obviously definitely doesn't mean that if you're GDPR compliant, you're automatically DPDP compliant. There are key differences like with consent centricity, differences in legal basis, breach reporting looks so different because we have to report to all breaches to all individuals. But it does give a great starting point. At least you have the inventories, you have the mapping and visibility over what is the data, and then you go ahead and plug in, fill in those gaps. And if you are an organization that is operating across the world, even there, just global compliance, often the starting point is knowing the data and then identifying some common minimum baseline key principles, key themes, while the specifics you'll kind of keep ironing out. Yeah. I wonder, Aman, if you have anything else to add on the global piece or
even the intra-group sharing piece, right? That is also an important one. So if any sort of loud thoughts on that, and we'll maybe close with this.
Yeah, I think even within a group, historically we've seen just blanket and catch all significant kind of data collection and sharing among these companies, but we should not take that for granted at all. I think each entity will have to see what its specific activity and role is, and not assume that this data sharing is permitted, because there is still consent still does need to be specific. It is given to a specific entity, the data fiduciary. So just identifying the different business lines, product lines where each platform might vest, and also the structuring among these different group companies. Are there instances where they are joint fiduciaries, in which case actually clarifying that in whatever privacy notices you show to the users as well. So I think also carefully thinking of each entity and what its activity is within a group.
Yeah, I think that's fair. I think if I were to just quite literally have a single line headline takeaway from this, it would just be the consent centricity in many ways of the Indian law, especially when we're talking about it in context of GDPR and a bunch of other frameworks. And I think that does cut across everything, right? Whether that's, like the point that you were just making, if it's data flows between at a group level or group and subsidiary, whether it's what we're doing in terms of notice and consent. But yeah, I mean, some of the, like, we don't really have too many, don't have like a legitimate interest equivalent essentially to rely on as another ground for processing. So I do think that that this is important for us to look at. But yeah, just want to be a little bit mindful of time. I know we've already overshot by 10 minutes. So what we'll do is we'll put a pin in this here. In the next week, we'll set up at least one, but we may have more of these in the coming week. The next one will specifically look at questions of retention. It will look at legacy data. It will look at employee data. Under consent, children's data and verifiable parental consent is not something that we've been able to touch upon today as well. And I think there was at least a one page of a Word document worth of questions that had come in on this. We'll talk a little bit about cross-border data flows as well, but I mean, I'm laying out a very ambitious list as I know I'm very ambitious as I'm saying this myself, and my colleagues are laughing at me as they're sitting around here, but we'll do our best, and otherwise we'll spill over into another one. We do have one on, we do have a whole series planned also on sector-specific use cases that's coming up. There's starting with the financial services one, maybe in early December, but we'll be posting information about this on our LinkedIn page and reaching out to you if it's of interest. Thanks very much for me. Please write into us if you have any more questions. And my apologies if we haven't been able to answer all the questions, but we'll do our best to get back. Sreenidhi, Aman, any closing comments?
No, I think we will let people go. But thank you all so much for joining us. Hope we were able to answer at least a few questions.
Keep the questions coming. Like this is,
Yeah.
we're so happy to actually have the final law here. So
it's been great. It's actually been my favorite format that we've done a bunch of these in. So yeah, keep the questions coming and we'll do our best to take them. Thanks, everybody.
Thank you. Bye-bye.
Bye.